Hey folks, we're going to be really informal this afternoon because we've got a relatively small crowd here today. Just some background. This meeting is now a regular meeting of the members. It'll be held every year at the end of October on the last Saturday. This was part of what we passed when we changed the bylaws in September. This meeting's intent is to give us an opportunity to offer changes to our bylaws and to offer motions that will establish direction for the coming board. We do not have a quorum. We didn't intend to have a quorum. There will be no legally binding votes here today. What we're trying to do is flesh out some number of member motions to be included in our election package that goes out in January. At that point, we will take a vote of the membership on whether or not to pass those motions, whether they be classified as a bylaw change or they be classified as directional in terms of establishing the direction we want the board to go in 2026. You'll have another opportunity to do this at the members' annual meetings. We'll be able to entertain additional motions and vote on those. Motions that do not get sufficient votes to pass, or if we don't reach quorum on motions, can be brought up again at the members' annual meeting, but we will have to have a vote sufficient to establish quorum for any motion that we put in the election package to pass. Does that make sense to everybody?
Yep.
Any questions at all? Okay. I got up to start this meeting because as head of the bylaws committee, I was helpful in, establishing this meeting. It doesn't mean I have to moderate this. Is there anybody else who would like to moderate this?
Who's taking notes? Is that you guys? Okay.
Okay. I'll moderate it. Between now and the board meeting in November, we need to capture whatever motions we make today and write them up in an actionable form that's explainable and present that at the board meeting in November. The bylaws now state that this is a standard part of November's monthly board meeting. So what we're going to do is we're going to capture the motions. We'll get a second. We'll talk about it. And then we'll move on to the next motion. At the end of the meeting, we'll force rank the motions that have been made. By that, everybody here will get 3 votes. They can cast one at a time. And we'll just go through. If we got 10 motions, we just want to know what's most important. What's the number 1 item that the most people want to make sure happens, 2, 3, all the way down through number 10. That'll give us an opportunity when we go forward to decide what actually makes it into the election package. The election package has limited landscape, and let's be honest, our members have limited attention span to read through a huge mass of material. So we don't want to overwhelm them with the number of motions that are actually in the election package. But we do want to include everybody's stuff that we can, given the landscape we have available. I believe with Election Buddy, we're limited to approximately 10 pages in terms of the hard copy that we're going to distribute. Some of that will be taken up by the election. Some of that will be taken up by the bios. Some of that will be taken up by the January newsletter that goes out. And some of that will be taken up by the member motions and whatever other things the board wants to include that have a need for the members to vote on it. All right? So we've got only so much space. With that, I'd like to throw it open and, anybody have any ideas of either changes they'd like to see in our bylaws or important things we'd like to see the board focus on last year. Coming out of the annual members meeting, we had 6 or 7 priorities that we established, and we've done pretty good. I mean, the fact is the members have an opportunity to direct what's going on in our community because it's our community. And this is an opportunity to open up to the whole membership your ideas about what should be done. Jim?
On the 22nd, people could have submitted. Did anybody submit anything, or Do you have any that you can read before we get started?
I did not get anything. John was checking on that.
I checked with Cindy a couple days ago, and she said nothing had been sent through.
So we received no electronic and no paper ideas through the office. Anybody? Yes, Jim?
Two motions.
Let's start with one.
Pardon me?
Let's start with one.
I'll start with one. This is from my wife. Any director who misses 3 meetings, 3 board of directors meetings, will have been determined, are deemed to have resigned and will be replaced.
Okay, this is a bylaw change that's being proposed, so it would require a 10% quorum in order to pass, and it's 2/3 vote of the members in order to pass. So the motion is
at the annual members meeting.
I'm sorry?
2/3 of the people attending the annual members meeting.
We can pass that as part of the election package, period. It'll be done. So if we have a quorum and it gets voted on and 2/3 of the people approve it, it's done. If that doesn't pass at that point, you can bring it back up at the annual members meeting. But we have, the whole membership available to us. That's one of the powers now that we're, starting to put things into the election package. It isn't just the people who live locally and show up here who get to determine the direction. It's all of you out there in the audience who live wherever you live can have a voice in what's going on in our community. So I have a question for you, Jim. When you say 3 board meetings in a row, we have regular board meetings and we have special board meetings or executive sessions, they're kind of interchangeable. Would the 3 board meetings be 3 regular meetings in a row? Would it be 3 meetings including executive or special sessions? What do you define as 3 board meetings?
I think 3 regular board meetings, and the reason is if somebody's out of town for 6 or 8 weeks, 3 executive sessions could be called and force that person off the board. That wouldn't be right. So 3 regular monthly meetings.
Okay. Does anybody think that's a reasonable idea? Second it? Mary Ann? Okay.
Jim,
So if you...
Could I just ask one? I'm sorry to interrupt you.
Go ahead.
Could you just state it one more time, Jim? I didn't get the very last part of it, but I wanted to write it down.
Any director
Yep.
who misses 3 meetings,
3 regular board meetings,
will have been deemed to have resigned.
Okay.
And will be replaced.
Okay.
Thank you.
And I'll work with you. Please capture Jim making that, and I'll work with you to get the appropriate bylaws identified and changed in the write-up that we send out to people to vote on. Okay? Do you have any others? Jim?
Okay. Other than, this is the motion, other than enforcement of existing policies, any disputes between the LCA and members will be resolved through mediation and, if necessary, binding arbitration.
Okay? So you're suggesting that we start with mediation and then we move to binding arbitration to resolve issues. Now that's issues being brought up by the board against members other than those things having to do with policies, procedures, assessments, and so on and so forth.
Or vice versa. A member can come after the board as well as the board come after members.
Well, I understand that you would like to make that both ways, but we don't have any authority over limiting what a member can do. We can ask them to go to mediation. We can ask them to go to arbitration. But if they insist on bringing a lawsuit right off the bat, we have no legal ability to say you can't bring a lawsuit against the board. That's federal law. Unfortunately, we can say our preference is that, and we remain open to that, and we would like you to, but the fact of the matter is, if somebody wants to spend their own money to sue us, they can spend their own money to sue us. If it's completely spurious, we take them all the way through the process and we stick them with the legal fees. I don't know any other way to handle that. So if we come back to the first part of Jim's motion, which is that the board will not proceed directly to bringing a lawsuit against any member with the exception of those things around liens and foreclosure and assessments and
All
policies and
violations.
procedures, those violations, the board will not bring lawsuits against members without first having gone to mediation and then having gone to binding arbitration. And if it's binding, we should be done at that point. So in essence, the board is not going to bring any more lawsuits other than those that are mandated in the legal process of managing our money and our community standards. Is that fair?
Yep.
Anybody like that? Anybody second that?
Can you say it again, please?
All right. I wasn't very concise. I agree with you. So,
Yeah, that was 10 pages worth.
right, Jim is making a motion that the board cannot bring in action other than those things constrained around our policies, procedures, assessments, liens, the things that require us to bring in action. The board cannot bring an action against any member. They must go to mediation with that member, and then they must go to binding arbitration with that member.
You're going to need legal review on this one.
Why?
I don't believe it's. I don't think it's. I don't have standing in the court. But that's what so we bring it out, then we go talk to somebody, and eventually have a legal review, and we find out.
We can do that, but this is our board. We get to set the rules for what our board can and cannot do. That doesn't mean that any individual on the board can't sue somebody using their own money, but not the LCA money. They can do whatever they like, just like an individual can sue the board however they like. But we have a right to constrain our board in terms of its actions. And I think any lawyer will tell you that.
I think it's
Yes, sir.
worded wrong.
I'm sorry?
I think it's worded wrong because I think you should just word it where you seek mediation or arbitration before any legal action is taken by the board for any reason.
Okay, so if
coming from the board side, they should try to resolve it through mediation or arbitration before. So you're leaving out certain things like money and all that kind of
so when it comes to foreclosure, all right, we're required to send a letter of foreclosure and those sorts of things. We're also required to make a legal filing.
Have we ever done that?
Not at this point.
Okay. I don't want to give you guys the window to do it.
But I mean, there are things there that we have the right to do in our
why
bio.
don't you use this? I mean, I'm okay with the mediation arbitration aspect of this, but try to resolve all of our issues that way first.
Okay. What do people think of that? Is that a better broadening of it?
Fair way to go about doing things. Than
Okay.
Trying to
Then
picking and choosing what you want to sue
Jim,
somebody.
what do you say?
Agree with that comment. The county's recommendation, I think we may still have some copies in the Longhouse, says three things to keep the courts from becoming overly congested, which they already are. Facilitation, mediation, arbitration. Facilitation doesn't really apply. That's why I said mediation followed by binding arbitration.
Okay. So for any dispute, we're saying between the board and members, regardless of what it is, we will seek mediation first, and then we will go to binding arbitration on that dispute.
And I know binding arbitration is supposed to be binding, but what if they want to push through to the next level?
They can, because
They
Jim's
can. They can legally.
anybody can sue.
Right?
Can reject mediation.
Yeah, they can.
So the board, what we're saying is the board has to go through these steps, right?
Yeah.
The member doesn't.
Correct.
The member can just
But
bring a lawsuit.
Okay. So yeah, it takes both parties that are at either one of these stages to have an agreement, correct? A binding arbitration. So that would, if there was a decision at arbitration, that means both parties have agreed to the terms, right?
If there's a decision in arbitration and it's in our bylaws that we all agreed to, abide by, it's binding on that person. At that point, if they will not comply, the only actions left to us are legal proceedings.
Or vice versa. Their only option is to.
If they don't like what came out of arbitration,
Right.
then there's no point in doing it.
Right. Well, I'm just saying.
I mean,
let's try that
arbitration
first.
is the decision. It's treated
That's
just
what I'm
like
saying.
it's treated just like the court said. This is the decision.
Yeah. But they don't have. So once that's done, it could go either way, basically at that point.
They could win. The board could win.
Yeah.
Jim,
I don't know if I think mediation sounds great, but I think the arbitration part of it, I think you need to leave it open to if somebody has to sue the LCA, they're going to do it no matter what. So.
If they've agreed to binding arbitration by voting as a membership, we vote for this. It is the same as the court deciding this is the answer. That's what binding arbitration is. Both sides are bound by the decision of the arbiter. All we're doing is keeping it out of the court system and trying to reduce the lawyer costs on both sides.
the mediator usually is, for example, in Hilo, the Kuakahi Mediation Center, they specialize in mediation and or facilitation. Arbitration usually is administered by a retired judge who is very familiar with the law, and so those decisions typically, when we say binding, are based upon his or her understanding of the law, not just an opinion. Mediation back and forth is, we agree to this, they agree to that, that's discussion.
Right. So if the state ever staffs the HOA office that's supposed to have been staffed for the last 10 years, that person will be part of that binding arbitration. It comes down, and that's the decision. Remember, this is for disputes brought by the board against individuals, not for disputes brought by individuals against the board. We want it to go both ways, but we can't limit the individual from immediately filing a lawsuit.
What about applying to vendors, the board and vendors? Somebody tries to rebuild this and messes up. I'd still like to see them go through binding arbitration as opposed to have the judge decide, which comes in thousands and thousands of dollars.
I tend to agree with you. I'm trying to protect your PC.
The point being that if we pass this as a bylaw, any vendor trying to do business with the LCA will be notified. The process is binding arbitration. By the way, just so everyone knows this, when you sign an agreement typically with a lawyer, even the lawyers who are doing the suing on your behalf, you're paying them, they have a paragraph that says in the event of disputes, any issues will be settled by binding arbitration. It's like, wait a minute, you're suing and taking all this money, but if we get mad at you, the lawyer, you want to have enforced binding arbitration? That's what they actually say.
Okay. I think we've got the gist of where you're going. I think in general we agree with it. Let's take a shot at writing this up at the board meeting on
14th.
on the 14th.
I think.
At the board meeting on the 14th,
Second Thursday.
we'll have all of these motions written up. We'll also post them on the website. We can come and we can discuss more some of the implications. That also gives the board time to seek legal opinion between the 14th and the 31st as to whether, 30th, it's only 30 days in November, as to whether or not this is a legal and enforceable amendment. Does that make sense?
Are we having a vote here today on this?
No.
Whether this is going to get on the list?
What we're going to do is...
I don't like the way it's worded. I'm just saying.
Okay.
It's the binding arbitration part. I don't mind if you guys take mediation to help resolve their issues. It's a less hostile approach to solving problems. But when you start throwing out the arbitration, how do I know as a member that the whole setup isn't rigged? That where you're going to get what you want no matter what?
Because it's a judge that's deciding.
Yeah, but I know how it's judges and attorneys and they're all having money
Anyway,
together.
we're not having a vote on it.
Okay.
What we're going to do is we're going to rank them in order of importance to us today. The vote will come when it goes put out to the members. At that point, we'll know one way or the other. But yeah, we don't have a quorum. Nothing we do today qualifies as anything that we can impose on anybody at this point. John?
I think of in terms of like the cost to the LCA overall, the lawsuits have rivaled all of the road construction we've done thus far and paid for from the eruption. I mean, several $100,000 to pay for fixing the roads that were damaged, the paved roads, and you know we're over $500,000 into lawsuits in the history. So this is critically important what Jim is proposing, I think.
And I agree with you, and I think as we write this up and we present it to the members, one of the facts we ought to give them is just what lawsuits have cost us, not just lawsuits brought against the board, but lawsuits the board have brought against people over the last bunch of years. Sorry, folks, I was sheltering it from the storm, and I seem to have accidentally hit pause on the recording. We're back. All right. Jim.
Point of clarification, if I may, in whether it's mediation or arbitration, the inference is it doesn't require the hiring of an attorney. Two sides get into a room and they hash out, present their case in layman's terms, but the person, the arbiter, is typically a retired judge who understands the law. So it avoids the legal fees. And so if we get into both sides having to hire lawyers, it's like having a lawsuit. Other than what we've learned over the last few years is the courts suspend or they reschedule, and it takes months, if not years, to ever get anything done. Arbitration is definitive.
Yeah, the courts are quite slow here in Hawaii, and it does have a tendency to inflate the legal costs on both sides of any issue that's taken to court. Anybody else got any ideas? Well, I'll throw one out then. We've talked a lot about our financial situation and about audits, and if you look in the bylaws, it's quite clear that the members have the right to call for an audit at any point in the year that they choose. And what I'd like to do is redefine some of the duties of our auditor to say that we require an audit once a year. And I go back and forth between December and January. The advantage of December is that we would have audited financial results before we elect a new board. So if the past board hasn't been very good at managing our finances, we'd know that. We could take it into account in our vote. The other time to do it would be in January, after January 1st and before the annual meeting, which would mean that when the treasurer gets up to present the year-end financial results, they would be audited financial results, and we know they were accurate throughout the year. So I'll bow to whoever thinks December or January. I think they both have advantages. If we do December, yes, the stuff in January is kind of audited, but we've had the January, the December stuff put into there as well. In both cases, the treasurer is being held responsible for stuff that happened before they became treasurer, right? If we do it in December, the previous year's December is off the books. In January, then the new treasurer is responsible for all of the information along the way. Does anybody have a preference one way or the other, whether we did it in December or January?
How long do you think the audit will take?
Well, given that we've established much better financial disciplines, it really should just be a matter of going through the systems that we now have and matching up to ensure that the deposits match up and the withdrawals match up. Um, we're not a big company. You know, it really shouldn't be as complicated as it seems to be. Um, I run my household on basically a budget and then a cash flow where I match. All right, I think I'm going to spend X amount for uh, gasoline every month. And every month I get a little report. I plug in how much gasoline I spent on gasoline. At the end of the year, I know how I ran against that budget. We're establishing something that enables us to manage our finances like that. That's what Janice has been trying to do all year. So it would be the goal to have the audit take less than a week. I mean, it shouldn't be expensive and it shouldn't be long unless people have not followed the disciplines that have been established. If they haven't, there's advantage to knowing that prior to the election so we can make sure whoever did that to us doesn't get reelected. If they followed them, it should be no big deal one way or the other. That leans me towards December. January leans me towards, well, then I'm holding them responsible for the whole year that they were responsible for the numbers rather than giving them 1 year of the prior treasurer plus
1 month.
their 11 months. So I go back and forth. John?
So if you wouldn't mind, could you repeat it? I have redefined the duties of auditor to require an audit. Take it from there.
So, Section 3 says duties. The auditor shall, as often as required by the directors, examine the books and papers of the corporation and compare the statements of the treasurer with the books and vouchers of the corporation, and otherwise make a complete audit of the books of the corporation, and therefore make appropriate reports to the directors, who shall, within 30 days of the completion of such audit, make a copy thereof available to each member. I would modify that to say the board is required to have an audit of the financial results at least once a year in either, we got to pick, December or January, the results of which will be made, if it's December, be made available to the members prior to the election. If it's in January, the results of which will be reported as part of the treasurer's financial report at the annual's member meeting.
And the system we have now, or incorporating QuickBooks, is that what we're?
It's a combination of an electronic mechanism for scanning and saving all of our receipts, which is in I think the system's called Lockbox. It's basically just a database that you scan stuff into, and then the financials themselves are in a version of QuickBooks, yes. Jim?
Clarification questions. The person who does the audit is or is not responsible for also doing the IRS or governmental filings.
This is simply audit. There's a whole section in the bylaws around auditors, around the fact that we as members have the right to, appoint an auditor. If we don't, the directors are required to appoint an auditor. That's our auditor for the year. And all I'm doing is defining as changing their duties to say they've got to do one every year, and it's got to be in this time frame. And we just need to decide whether we'd prefer December or January.
What are the requirements for an auditor? Just a CPA?
It's got to be a firm that's accredited and acknowledged as an outside audit firm. Yeah. It cannot be a member, and it cannot be a board member. Yeah, it's got to be outside the LCA. Disqualification, Section 2. No director, officer, or member shall be eligible to serve as auditor of the corporation. I wouldn't touch that. All I'm doing is touching the duties to mandate a once-a-year audit.
I like the timing of it, specifically for the purpose of the treasurer, because we've seen members' meetings where at best it sounds incomplete. The treasurer's report very opaque. So I think that would have something in hand from an auditor would make most people, I would believe, feel better especially the treasurer, to kind of check their work, to say, hey, you did fine in this department, and
So you favor the January audit,
December.
December or January?
long as it's available at the time of the members' meeting.
So the December audit will be available for both the election and the members' meeting, but would not include the December results.
Of the election.
The December results would be unaudited.
Oh, okay, right, I get you.
Because we would have done from December of the previous year up to the end of November of this year.
Yeah.
Right.
If we do it in January, it would go from January of that year through the end of December of that year. So that's the only difference. I mean, can we live with 1 month of unaudited financials at the members' meeting? Probably, because 11 months or 12 months are audited, and 11 months are the treasurer. So December, Rob?
So our annual taxes, our federal taxes are in March,
April.
So any of this audit, is it going to be duplicated again just before tax time?
You should not need an audit to prepare tax forms. I mean, it's a pretty simple. Yes, there are a couple of months in there of the fiscal year that have to be reported on, but I don't know. Does the taxing authority do it on a calendar year like they do for all other corporations and stuff for a nonprofit, or do they run on your fiscal year? I think it's still on a calendar year.
I think we chose to do it at the start of the corporation. But what would happen if we paid our taxes in conjunction with an audit?
April 15th is the filing deadline.
Right. You can pay your taxes.
Pay your taxes January the 2nd.
Okay, I was just
right. I didn't explore the taxes implication. I just know that there's been a lot of talk and mistrust in the numbers and wanting to get transparency of the numbers. I figured this was a quick and easy way to do it. If we do it towards the end of the year, we know that what's being presented to us and what's in the election are clean financials.
I like December.
You like December? December? All right, I'll write it to be December then. Thank you very much. So that was mine for today. Anybody? Yeah, Chris.
Okay. I would like to have the bylaws mention, acknowledge HRS 205, 4.5, and 4.6 agricultural laws in the state of Hawaii as it pertains to Leilani Estates. And I would like the HOA to utilize that law and how they, or at least reference that law on how they enforce CCNRs in the neighborhood.
Okay. That is, in fact, CCNR changes.
It's not a CCNR change. It's how they go about enforcing the CCNRs that are on the books.
Right.
That you can write in the bylaws, hey, we acknowledge that this law exists. We
I agree.
acknowledge that it limits us in certain ways as it pertains to the CCNRs. I'm going to read something for you real quick, and this is from my notes. Hawaii Revised Statute. Let me finish. Hawaii Revised Statute, HRS 205, 4.5, and 4.6 primarily govern the permissible uses of agricultural land and the limitations on private restrictions on such land, which should apply to a Leilani Estates as it is classified agricultural land. HRS 205 and 4.5 establishes the types of uses permitted within the agricultural districts, such as cultivation and livestock, while HRS 205 4.6 invalidates private restrictions that would prohibit or limit these agricultural activities, with specific exceptions for certain easements and environmental protections. Therefore, Leilani Estates CCNRs must not contradict the uses permitted by HRS 205 4.5, and the CCNRs recorded after July 8, 2003 are generally void if they attempt to prohibit agricultural uses. That's
what was the last bit that you just said? After
Therefore.
2000? What things after 2003?
Okay. Therefore, Leilani Estates CCNRs must not contradict the uses permitted by HRS 205 4.5,
right?
and any CCNRs recorded after July 8th. Now, it's any transfer after July 2008.
Okay.
Oh,
what you
I mean,
read
I'm sorry,
doesn't say
July
that.
8th, 2003 are generally void if they attempt to prohibit agricultural uses. So any transfer, the law says any transfer of any parcel that, so
Okay, so that was just
basically,
whoever wrote that mistyped that.
yeah. So basically, any parcel that has transferred since that date is no longer, you're not able to enforce this. If a CCNR is in contradiction with that state law, you're not able to enforce it.
Clearly, the legal authority is federal, state, county, charter, CCNR bylaws. So state law definitely.
All I'm asking is that for the HOA to clearly recognize that the state has the authority to zone. They have the authority to make these laws that restrict private restrictions, and just govern with that in mind. That's all I'm asking, because you would save yourself by ignoring it, because they've ignored it for 23 some odd years. By ignoring it, they're just setting themselves up for a lawsuit, because as soon as they start going after people for a cow or whatever, and I'm saying the stuff has to stay on the property. They have to. I mean, that's just common courtesy. You know, your dog has to stay on your property.
Right, but it happens all the time.
It happens, but hey, but this doesn't give the law doesn't give any wiggle room. You can't say, oh well, you can only have 10 chickens. It's very clear. You cannot have any private restrictions after that date.
On any transfer after that.
And on any transfer of property. So I would even question how many properties in Leilani Estates have been transferred since then. How many properties in the neighborhood are still left that you can still enforce?
Well, I totally understand what you're saying. It seems to me, and I'm just talking now as, with you, that this is something that we need to get a written legal
This needs to have
opinion
a judgment on it.
as to which of our bylaws are invalid. Just let me finish.
Okay.
Which of our bylaws are invalid, totally. Which of our bylaws can be enforced totally, and which of our bylaws, not bylaws, I'm talking CCNRs, can be partially enforced but not do certain things, right? Because some of our bylaws, some of our CCNRs can be enforced. Some of them probably can't.
But let's just take the house.
There are also some definitions of agricultural use that I think would be useful to have.
It's all spelled out in 205.
I understand, but there are some things in there that people are interpreting as ag use that I wouldn't say are ag use. For example,
but you don't get to make that decision.
No, either do
That's
they.
The state gets to make that
Either
decision.
do they. What I'm saying is, for example, there's an auto repair shop that operates down near John, right? He's an auto repair shop. If he repairs a tractor once every 3 months, that's not ag use of his property. But he's saying that is ag use of his property because he can also repair tractors. That's something
they went after a guy up the road here for welding on tractors and said he was commercial, and they shut him down when all he was working on was tractors, and stuff like that. And it's
I understand what you're saying.
That wasn't lawful, is what I'm saying.
There are other things like that I think are open to some degree of interpretation that we could use some legal opinion on. Jim?
Could I suggest, as opposed to a change to the bylaws or CCNRs, that a motion be made to have a legal opinion by a paid attorney rendered on the application and implication of 205, whatever they are, and its impact on the LCA.
It could be anybody's attorney, and they all have different opinions.
No, they don't, because you just said the law is very clear.
The law is very clear, but we're obviously there's an attorney involved that is pushing back on it. Okay, is Ted Hong pushing back on it or not?
No,
He's not pushing back on it.
No.
Okay. I'm just trying to get it all out there.
What he's trying to get at is there may or may not be nuances around some of the things that we can do.
Well, the main thing is when it comes to CCNRs, like say if somebody wants to put a greenhouse on a property or a shed for ag use, and the thing is it's for commercial or personal use. Doesn't matter. Okay, your land is your land, and it's protected under this law. And people try to say, oh well, a commercial operation, so you can't do it X, Y, and But it doesn't matter if you're growing bananas, mangoes, whatever the heck, avocados or chickens, whatever the hell. It doesn't matter. It's for your use. Okay? And the state has made this law to protect you, even though you may not want to utilize that land for that reason. One of the uses of agricultural land is for a single family dwelling, okay? But it's not the only thing you can use it for. And so the CCNRs basically say that you can only use an acre of this land for one single family dwelling, and that's it. You can grow your bananas, but they're saying you can't have any other animals other than the dog, cat, and a bird, which is unlawful.
And that was written before 2003.
Okay, I'm just saying, I would like to have the bylaws reflect that.
All we have to do is have the lawyer review the bylaws and CCNRs after reviewing the applicable law here, as opposed to a singular reading of the bylaws and then a reading of the CCNRs. Have that law in front of him or her, and then read the bylaws and CCNRs and find the applicable or, if necessary, points of conflict.
So let me see if I can get somewhere in between those two positions for you. It may not make sense, and tell me if it doesn't. But it seems to me that what we have here isn't a bylaw change, because the bylaws don't have an effect on the CCNRs or the lower level. So what we want to do is establish a direction for our board. This would be in the board directional category versus a bylaw change to me. And what it would say is, we, the members, recognize that the 2003 agricultural rules have had a significant impact on our CCNRs. We require the board to put together a legal opinion on what can and cannot be enforced and report back to the membership. That report will be attached to our CCNRs as an addendum. Changing our CCNRs is remarkably difficult, and they made it that way on purpose. That doesn't mean we can't establish an official addendum to it that's an interpretation of the state law that we can point at as, this is how we're going to try and interpret it. Doesn't mean people can't sue us over it. But I mean, the only other option is to say all of our CCNRs is invalid, and I don't think anybody wants to do that.
Not saying that. I'm just saying that they need to look at it through those goggles and apply it.
I agree with you.
Okay, this is what the law says. How can we? The law's not allowing us to enforce this particular CCNR. That's what it says. It says that CCNR will no longer be enforceable.
I agree with you. There are CCNRs we have that cannot be enforced.
Okay.
And I'd like to be able to call those out specifically so that the architectural committee doesn't make mistakes going forward.
Well,
and that
it
people
is a
who
very
buy
broad
lots here,
list.
and people who buy lots here have a document they can look at and say, that's what people can and can't do. And I have to understand that if I'm buying here, if somebody wants to put a solar farm next to my property, they have every right to do so. Does that make sense?
Yeah.
John?
Yeah. Regardless of how we define that, and I think it's a good idea to have a legal opinion and addendum, but there'll always be situations where a resident is going to come into conflict because of their interpretation of, or as we see now, it's an ongoing situation where a resident is claiming that for agricultural reasons they needed to park a number of old school buses on their property. but it aggravated the neighbors because they put those buses in the setbacks, and the people who live next to them, they're affected by noise, light pollution, improper hookups for a septic system type of thing. So it's a bone of contention, and so for the board to get into that is it's kind of endless, you know. It's like it'd be nice to, when that does come up, that we could say, you know, there is a way that neighbors can resolve these things through arbitration, but this is our stance in black and white.
Well, and hopefully the mediation arbitration passes, and we'll be able to do some of that. And, you know, one of the things to think about, I think, is that there's a difference between if you want to live on the land and use it for ag purposes, or if you just want to use it for ag purposes. The habitation parts of that are still subject to county rules around habitation. And they can also, and that's where I'd like to see interpretation, they can be subject to some of our CC&R rules. What those rules are and which we're allowed to use is where I'd like to see a legal opinion, Chris. So, for example, you know, you want to put up greenhouses and raise chickens on your 2 lots, but you're not going to live there. You know, you can do that within the rules the county has established for construction of greenhouses and everything else. You want to put a house on that, the county says you still got to have septic. You want to live there. The county says it's still got to be permitted. You know, those are parts of the things that we can interpret. Now, whether or not we can say it must be of this size or not, for the habitation only, for the habitation part of it, is something I'd like to see an opinion on. Can we still restrict the height of the habitation? I'm not talking about the barn or the silo or, you know, the greenhouse. Can we still do that? Can we make sure that they have a garage? Can we still do that? It's those things around the habitation component of how somebody uses their yard, not the ag component, that I think we can still enforce.
Well, for example, before, if you dozed your lot at all, you'd get a letter, and they would want to see your plans. And basically, it was kind of given the idea that you couldn't utilize your land until you had building permits, which isn't true. That isn't true.
You may know more about it than I. I don't know what the county and state regulations
No.
are.
This is the HOA.
I'm saying on constructing greenhouses or anything like that.
Before the eruption, if you were to start to doze your lot, and if you didn't have a set of plans up here, they were coming after you. They were sending you letters, a violation letter, yada, yada, yada. That's because in their interpretation of the CC&Rs prior to this eruption, you can only use the piece of land for a single family dwelling. Period. That is the only use of the lot.
But you can clear your land, I would have thought, and this is just me as a person.
I'm just saying,
I would have thought that anybody could clear their land at any time. I mean, I've got people in my neighborhood who obviously cleared their land.
I cleared my lot. I
planted and landscaped.
Luckily, I haven't been building permits at the time, but
you know, they've been doing that for 10 or 15 years.
I cleared a lot here on Moku. They sent me a drone footage of a drone picture of my lot that I cleared. I'm like, yeah, I know. What about it? And then I get a letter about 2 weeks later.
Isn't it lovely?
They told me that. It looks great. And then I get a violation letter 2 weeks later. I'm like, rat bastards, you know? It's like, and they were trying to tell me that I was in violation. I said, violation of what? I know what my lot is. I'm just saying
interpreting they're interpreting land clearing with the beginning of construction.
Right. But it's not the case.
And it shouldn't be the case.
No.
I agree with you.
Okay, that's good.
That shouldn't be the case. Jim?
I like the idea a lot of putting an addendum, whether it's to the bylaws or CC&Rs. And the reason for that is over the past several years, and this is part of Chris's complaints, I think, speaking for Chris, one lawyer says this, the next lawyer, and to use some specific names, there's a lawyer named Hasagawa from 8 or 10 years ago. He issued an opinion. Well, then the next go around, Lincoln Ashita issued a different opinion. Then they sought an opinion from Terry Revere, and he issued an opinion. And now we have different lawyers. If we have a lawyer who understands whatever you say when you read and interpret is going to be an addendum and other people are going to be reading it. I think we can put it in writing and have it in place. Doesn't mean that we can't get sued.
We can
But it can be
also
an addendum.
attach it to the, we can also register at the Bureau of Conveyance so that it becomes a part of the legal contract everybody signs when they sign up. Again, it
it's
doesn't
never
limit-
mentioned. It's never mentioned when people are, you're talking about CC&Rs. You know how you go and close on a lot. The CC&Rs. You got to say you acknowledge that Leilani Community Association has CC&Rs, whatever. This is if you're going through escrow, and you could just simply put, hey, this just like Cokie Frog's addendum. HRS 205 4.5 4.6 addendum. This is
Cokie Frog.
Yep.
There's a cookie.
No, you're
There
right.
is a Cokie Frog addendum and Lava Zone 1 addendum, right?
Only raised 2, right?
I think you're over, man.
If the density exceeds
I'm
40,000
just
per
saying,
acre,
basically multiply. It helps people do their due diligence. That's all.
I agree with you. And when I bought my lots, my realtor, for whatever reason, was diligent and actually gave me the CC&Rs and gave me copies
Yeah.
of these things. But that was back in 2006 or 7, so I don't know what they're doing now.
Staying on track. John, do we have whatever it is the motion is going to be?
My last rendition was, how bylaws reflect the ag law and how they are enforced, how they change the bylaws.
Tag it to Chris and Jim. I'll work on the notes of that, and I'll send it to you two guys, and you guys can play with that, and we'll get it into a form that
Before the next board meeting.
you're both comfortable for the next board meeting. Is that cool?
Yep.
Okay. What else? Anybody have other suggestions?
Caroline had
Okay.
wrote something down for me regarding lava lots. She wrote 3 different things, and they're quite different from each other. The first one was make a motion to establish quotes for what it could cost to rebuild roads and access to lava lots. Then any fees, dues paid by lava lot owners are saved into a specific fund that would that they could access and be matched with infrastructure grants, perhaps necessary to make them come into compliance. It says try to seek matching funds from the county or grants, but basically it sounds like establishing quotes is a start. What it would cost to present to the members a sketch of sorts of what it would cost to rebuild the roads, and take the temperature of the lava lot owners, and not only the lava lot owners, but all owners who are pitching in to this imaginary idea of a fund to rebuild.
So I think I understand what you're saying.
Yeah.
I'm going to make a couple comments on that, and then throw it out. We have rough guesstimates of what it would take to pave the 5.5 miles of road that are currently under lava. The county's told us it runs somewhere around $4 to $5 million a mile, right?
A mile?
A mile. So we would be looking at somewhere between 20 and 23 million to pave those roads. Now, that's in today's dollars. All right. By the time we save enough money to get $23 million together, even if we were to, let's say we doubled everybody's dues, and the 500 lava lots paid $500 that all went into this fund, and everybody else paid $500, of which $280 went into the fund, it would take us somewhere around 25 to 30 years to get the money together. Now, that doesn't mean we couldn't do it in phases, but that's a difficult project to take on, particularly understanding that pricing is only going to get more expensive. That's if we could go get a loan today and go do it. putting cinder roads in is significantly less expensive. It's probably more in the $6 to $8 million range. Smiley's trying to nail down an actual number from the county on that. We could again. Can I finish first,
Yeah,
Chris,
yeah,
and then I'll
go
get you. We could again get the money together by raising dues and segregating the money out. That's again something that we could start to do immediately, right? We could open up, start working our way down. To do that would either require the board trying to force through a special assessment on everybody, which I don't think is reasonable to do, or a vote of the membership to say, yeah, we'd like to reopen those lots and we're willing to take on the financial burden in doing that. We don't know what the temperature of the community as a whole is at all, right? So I think until we understand whether or not this place has the stomach and the discipline to accept significantly higher dues with the intent of opening up the lava lots for everybody, we can't really make a decision one way or the other on it.
Can I go to the other end of the spectrum?
Well, let me ask Chris first. He's had his hand in the air.
Okay, so Jim and I are going to have a meeting tonight at 7 o'clock with other Lava Committee members. We've established the list and the map. So we've narrowed down. I know some of them you guys might test, but we've used the criteria. Does it have lava at all? Wherever, as far as from the 2018, is it assessed at $100? So meaning the county's not taxing it. Is any part of it behind a barricade? We try to be as inclusive as possible so we can not leave people out. Okay. And what we want to do is send out a letter to all these folks and ask them, what do you want to do? If you're going with the idea of brand new roads, this is exactly what you're saying. It's going to cost us dearly. Okay. And considering how many buyouts are out there, I mean, you might have a street that's got a lot of buyouts and only a few vacant lots. Why in the heck are you going to build? I mean, but according to the bylaws, you're obligated to make a road. But we just want to test the temperature. Hey, here's a survey. What is it that you want? Here's the realistic expectations. I mean, you could be special assessed for a promise of a road one day, like 20. It takes a long time to earn up all this money to build a road. You can try it in increments, or you could just not be charged and just be happy with it, with how it has been basically. Some people it's okay with, but you can't get in the way if they want to build a road, their own road, you see.
So, good information. I think it's important that we do survey the membership,
That's our plan.
but I think it needs to be broader than simply the lava lots, because it wouldn't just be the lava lots. So there could.
It's going to encompass the whole neighborhood. Everybody's going to have to pay.
That's right.
Like $9,000 a lot to build roads down
there. Basically.
Basically.
So again,
I'm not willing to ask that of my neighbors up here. Just because I have them down there, I'm not willing to ask that. So I'm just saying that that's what our plan is this afternoon. We're going to narrow down a letter, and I don't know if we gotta get anybody's approval. I don't see why we need to get anybody's approval, but
Your committee.
I mean, we can.
well, you're certainly able to do anything you want on your own. There's nobody who's going to stand in the way.
Have them answer it honestly, like what do you want to do? What do you perceive the future of this place? Because
so again, this is a community of 2,000 and some odd lots. It seems only fair to ask the entire community what they want to do, because if the entire community is willing to make that financial commitment, then we ought to go do that.
I mean, if they come back and say we want new roads, you have a mandate. You have a mandate for roads.
Well, we don't.
But Well, I'm just saying that if they want new roads, that's what kind of pressure does that put on the folks up top, that are unaffected, uninundated? That's what the reality is. It's like, so my whole point about charging out there is not right, because if you are charging them, you are trying to govern them, and you are not offering any services to them. They're not offering the same services as they do as they have. So it's you're setting yourself up for a lawsuit or a mandate.
So,
Because I know that they wanted to charge, eventually.
so,
We're not sure who they is, Chris.
so,
Yeah.
You use a lot.
Hey, even if we get this board out of here and then the next board or the next board after that, somebody's going to see that as a cash cow, like we can get money out of them and not offer anything. That's not right. Or you got to have
Brian?
some sort of
I'm sorry.
service.
Brian?
Is the county, all county owned lots, do they pay dues like everybody else, or is it separate?
The application of dues has been incredibly inconsistent in the lava lots. There was a waiver of the dues for a while that wasn't valid underneath our bylaws. There was an inconsistent application of a $100 due that wasn't legal under our bylaws. And there are also some people who got charged $220, which is legal under our bylaws. So the county has and has not been billed depending on the year and which lots we're talking about.
According to our bylaws, though, are they supposed to, or do they have an exemption with their buyout?
There is no exemption for anyone in our bylaws or in our charter of incorporation. If you look at it, everybody's a member and everybody has the obligations of a member. Now, as a corporation, we were founded to do certain things, right? One of those things was to improve the roads and maintain those roads. The other was to have common facilities that we can all use and improve and maintain those facilities. That's what the assessments are for. So under our structures, under our current structures, we should be, in fact, saving all the money to open up those roads eventually. We have to make a decision as a community whether or not we want to do that. I mean, if we don't, then clearly that directs us to do certain things in terms of how we treat the lava lots. They're still members. They still have the right to vote. Do they need to pay any dues for the fact that they can use the facilities and the private roads to get to their lots? That's something to be debated. Should they pay any dues if they're off in the middle and they don't live here and they don't do anything? I don't know. That's still to be debated. But we've got to directionally know what the community is willing to do, and then we can rewrite our assessment process. Because right now we got two choices in how we assess, right? One is we take the budget, we divide it by the number of lots, and everybody pays the same. Option number one. Option two is we take the budget, we divide it by the square footage of frontage each lot has on a road, and that becomes what each person pays. So corner lots would pay more because they have more frontage. Lava lots that have no frontage at all would pay zero, right? Lava lots that have partial frontage, you could say, well, you got 75 foot, you pay 3/4. I mean, that's what our bylaws allow us to do today. I think that doesn't help our situation. I think we need to rewrite the assessment process. But until we get a reading for whether or not we're going to do anything with those lots, I wouldn't know how to assign values to it. Chris, I struggle with it because I agree with you. I think there are things we ought to be doing for those people.
And that's why we want to take the temperature first. Is that fair?
What?
With the letter and the survey, we want to take the temperature of what those folks want.
Well,
because ultimately they are the ones that are waiting.
Could could we compromise and put it in the election package and take a survey of the whole community and have a box to
I'd
check?
like to do it before then. I mean, we're gonna, as soon as we get a letter together, I would like to send it out sooner rather than later. I mean, we're just wasting time.
Well,
I mean, you put the lava lock committee together for a reason.
so if you send it out,
It's the only way we can move forward.
can I just put some hypotheticals out there? If you send it out there and they all come back and say we want roads,
Okay.
that has no binding effect on anybody.
No, but it just lets you know
That you guys are willing to raise your rates and contribute. If they come back and say we don't want roads, that still has no binding effect on the rest of the community. They have the right to vote against that, but if the rest of the community votes for it, we'll put roads in. So I'm just trying to keep from establishing an expectation that the survey means something other than it's directional. If you're careful in how you word it, I think it's fine.
I want it to be as clear as possible. Like this is where we're at. If we go this route, this is the expectations. This is how it's it's going to cost X amount of dollars per person in the neighborhood. It's not just the lava lots having to pay for it. Because if they thought somebody else is going to pay for it, of course they'd want it. But it's not
Right.
the case.
No, everybody's got to contribute. It's a community.
Right.
We're a 2,000 lot community. Yes, sir.
Just an idea for votes like this, rather than wasting money mailing out to people that we don't have information on, having it on the website and having a mass email sent out to anybody who wants to be a part of that.
Unfortunately, we don't have enough emails of the people in the lava lots to, I think, really get the reading that Chris wants.
Well, the thing is a lot of the land that is still out there that is privately owned is owned by trusts. And the thing is the reason why the county didn't get all these folks in the buyout is how many people are on the trust. You don't know if they can't decide on to sell it to the county. It might be one person got the mailing, tossing the trash.
10 kids.
Yeah. 10 people on it. So, and I told Douglas Slay that. I said, hey, it's mostly trusts out there that you didn't get. And they know it's a problem. So.
It's a kind of an open-ended question too. If the county owns hundreds of lots out there, right? We're into the hundreds.
Yeah, we're in the hundreds.
And they're put on the hook for road rebuilding. Who knows if they say, guess what? We're having a fire sale on lots. You know what I mean? Right.
Or, they may choose to exercise their vote for a change and say no. Instead of just saying we're present, they might choose to say no. They've done that in some of the other HOAs where they really didn't like the implications to the county of what the change would be.
Did you say this was going to be a quick meeting?
Yeah, let's
I'm just kidding.
keep rolling. We are. So, where are we? Let me. There.
Do you have any motions?
So, here's where I think we are. Chris, go ahead with your mailing. You want to take the survey of the lava lots? That's your right. You've got access to all the information you need. Go ahead and get that. I think I'm going to make a motion at the next board. I'm going to make a motion at the next board meeting that the board add to the mailing for the election a survey of the entire community and what they would like to do around the road situation in the lava lots. So
I think you need to highlight exactly how much you.
Absolutely.
Okay, option one, no road. I mean, private owners get to make their own roads as needed when they feel like it. And option two is HOA goes in and tries to reestablish roads and how much it's going to cost everybody. I just want to spell out everything so people understand that it's not going to be a long endeavor. It's going to be an expensive endeavor. It's going to be more expensive than everybody wants, especially people on fixed incomes, things like that.
we'll have to look into the implications of people just willy-nilly putting roads in, because there's got to be along the right-of-ways that are currently defined as roads, so it doesn't encroach on other people's properties. And legally, that isn't your property to improve. So there will have to be a review and approval process associated with that. But I wouldn't see that being a problem if we end up at a point where the membership doesn't want to do it themselves. We're responsible for the roads. It's clear in the charter and other things.
How much money did we spend in 2019 when they paved 700,000 for Moku Ono, right?
Others, there's a bunch of streets they
Without
patched.
what? A permit? The county was pissed. They did it without a permit.
So that's history.
I know it's history, but I'm just saying. Now we're trying to.
We're trying to get back to ruling based on law and structure. That's what we're trying to do. I know that
Got to cut grass in front of their 100-foot road frontage. If it's 100-foot road frontage, that's 100%. If it's not, prohibited.
so. Neither here nor there. We've all had to plow down lava structures on our yard. I mean, I had to fill in a 25-foot ditch in the back of my yard. I had to plow through a lava ridge in the front. Just because you've got 10 foot of lava in the front, if you're living in your house, I would argue that you should have to pay. But that's me.
Let's move on.
All right, next. Anybody else have any motion?
I just want to read the last one. This is the complete opposite end of the spectrum to what Caroline had proposed in the first one. It was motion 3. She says, rewrite the bylaws to include a clause that temporarily suspends lava-covered property owners from having to pay dues until the properties are accessible.
What is the define accessible?
That's
HOA-funded
the
roads.
And what is the definition of what a lava lot is?
right.
Is the problem.
We've already
Yeah.
got
We have a recommendation on what a lava lot is.
Right.
That isn't something that,
that. He's got the list.
I understand.
We got the map.
That's a recommendation.
No? Are we done?
Anyway, I think that falls into the same category as stuff. We've got to make some fundamental decisions before we can decide that.
Right.
It could certainly be put on as a directional one for 2026 and say, we direct the board to exempt the lava lots from dues as some definition of what they are for 2026 until we decide what the long-term strategy is and vote as a membership, and then apply assessments from 2027 going forward if we choose to do that. But I don't think as articulated we can really,
Right.
do that one today.
Yeah. It's pretty clear though that we know why we're 7 years we're in this position, because it's such a huge undertaking on so many levels, as far as not only just defining lava lots, contacting people, the funding, the feasibility. If you just simplified it down to the most simple stretch you could, if you went to the end of Leilani Ave and you looked across on South Nohea, right? It's got an ending where it reaches pavement again. How much would it cost to make a road? I mean, across that. I mean, I look at it incrementally, but it's not necessarily fair to other people who are waiting, like that have zero sight of a beginning and an end. So there's so many ways of looking at it, and it has to be equitable for everybody. You just can't pick willy-nilly and say, we're going to open up this place, even though the county assisted us in reestablishing contact with North Luana.
We would have to put a strategy in place, and the most reasonable one would seem to be you extend the 2 connector roads on the outside first,
Yeah.
and then you start to build in from there, and you go from there. I don't know what the answer is either. All I know is that we are a community of 2,000 people, and it's not going to change anytime soon. So we need to figure out a way to treat all our members fairly. And right now, um, under our bylaws, we can't treat all of our members fairly, and that's unfair. Oh boy, here's a tautology for you if you like one.
It's unfair that it's unfair.
Anybody else got anything?
Thank you.
All right, well, if you want to go stand in the rain, it's smoking up over at Maku'u where they're doing
It's clearing off here.
wild pig
today.
stuff and all sorts of interesting chefs and music and everything else. Thanks for coming, and I appreciate your time and your involvement.
Thank you.